Federal Judge Stephen McGlynn says he is inclined to not issue an injunction in the request to delay the January 1st deadline, while you've also got another filing in front of the U.S. Supreme Court in the case that Dan Calkins has brought against the state's gun and magazine ban. Welcome back to Bishop on Air. Yesterday was a busy day for litigation against the gun and magazine ban. I was down at the Southern District Federal Courtroom in East St. Louis, live tweeting out the Federal Firearms Licensees of Illinois' challenge of the January 1st deadline with Judge Stephen McGlynn hearing the oral arguments. So you've got that we'll review, and I'll just kind of run through the tweet that I posted. Reminder, if you don't follow me on X, be sure to follow me on X, because when there's these types of things where, you can't join a phone call or a Zoom or whatever, you have to actually be in the courtroom as a reporter with the credentials. I'm able to tweet out, to post out. I can't do live video or audio, but I can send out notes via X or Twitter. So that's what I did Tuesday after traveling down to East St. Louis to check that out. But we've also got to just briefly look at the latest filing from Dan Calkins in the U.S. Supreme Court, where he has now filed for a writ of injunction submitted to Justice Amy Coney Barrett. And we'll take a look at this document as well. We knew this was coming, but now we see that it has indeed been filed with the receipts. So we'll get to that as well. But let's go ahead and jump into the live tweets I posted from the Southern District of Illinois, where you had the case being heard, the Federal Firearms Licensees of Illinois in front of Judge Stephen McGlynn. The case called to order. The judge had mentioned that litigants are on Zoom, but he was having trouble hearing some of them. That eventually worked itself out. But he says he wanted the courtroom to be open to the public to come in and view the proceedings. There were a few people in the courtroom. There were several media, including myself, but there was only one member of the public that was in the actual courtroom. And the judge came out and said that two motions were going to be heard: a motion to enjoin the deadline, meaning enjoin means to block enforcement of the deadline. So when you hear some of these terms, and I appreciate the feedback I get from you guys, some have said, hey, can you kind of boil it down a bit more to make sure it's easily understood? And so to enjoin means to block. All right, I'm not an attorney, but just tracking all this as long as I have, you kind of feel like you got your junior law degree. But regardless, the judge said two motions were going to be considered, enjoining the deadline and also the state's motion to dismiss. So we'll get to a little bit more of that later on. But the plaintiffs, they then went into their arguments as to why the motion of enjoining or blocking the January 1st deadline should be granted. They talked about proper notice. They talked about vagueness. They said the circumstances matter here because things are egregious. They said that registration, there's been a lack of notice. They also talk about the possibility of property being taken, significant jail time if somebody doesn't register and does so for items that the owner doesn't, the actions the owner doesn't take. The plaintiff said if you do something and then you don't act, there are consequences, even actions from decades ago. And that was around the idea of say somebody bought a firearm 10 years ago. And now if they don't act on something they did 10 years ago, then they're going to be punished. So that there were questions about just the due process of that. Plaintiffs noted all the firearm owner identification card holders there are and the low rate of registration. They said that was indicative of inadequate notice. But the judge went on to say that could be one thing, or it could be about protest. The judge said, should the prudent thing to be to wait and see what happens by January 1st and then deal with problems then? The state expects a lot of last-minute filers, the judge said. The plaintiffs say notification is only one issue. Then the state may expect more registration, but Illinois State Police registry rules still not complete, the plaintiff said. So they talked about the earlier in the day, Tuesday, and we reviewed this in a different segment. Encourage you to go check out the highlights from the JCAR meeting. But the plaintiff said JCAR did not take up rule revisions, and with 2 weeks left, the rules still aren't finalized. So that was a major point that the plaintiffs made, saying the rules are still not final rules. They could change even after the January 1st deadline. So some clear questions as to just the process where we're at and how there's lack of clarity. The judge asked if rules have been promulgated. The plaintiffs say they have been, but due process, the plaintiffs say, requires a review of the circumstances and the consequences. And they say this has potential jail time as a consequence. Plaintiffs say that they're not taking issue with Illinois State Police, but they say the administrative process is not complete. The judge says penalties have a component of only having charges when they knowingly violate the act. Quote, this is a paraphrase, but if it's this confusing, how could they possibly prosecute? It's an interesting quote. The judge went on to say that there are problems understanding what is and what is not covered. And he says if enjoined, if the January 1st deadline is blocked, he's not sure it'll be resolved. The judge then went on to talk about the Second Amendment sanctuary counties across the state, and there are dozens of counties of Illinois' 102 counties where they have passed resolutions saying that they won't enforce gun control measures like a ban on certain types of firearms. So the judge acknowledged Second Amendment sanctuary counties. He says if enjoined, if the January 1st deadline's blocked, then he says people will point the finger at the federal court. And there'll be a blame game going on. He also asks if following the January 1st deadline comes and they address problems then, the plaintiffs say there are real consequences for those who don't comply. So they, of course, continue to double down, asking the judge to ultimately block the state from that January 1st deadline. Plaintiffs talked about consequences and what it would mean, loss of constitutional rights on a wide scale. They continued arguments saying that it's unique and it's warranted to have the January 1st deadline delayed while the case proceeds. They also talk about pre-enforcement challenges because of vagueness in this case and highlight some other case law that they had ready to talk about how judges can do pre-enforcement actions when there's vagueness in the law. The judge discussed the difference between facial and as applied when it comes to vagueness, said that registration schemes could have shortcomings and unlawful failings, but the Supreme Court of the United States, the judge said, doesn't want broad sweeping stays, which means, blocking a law from being enforced. The Scottish Supreme Court of the United States, McGlynn said, they want more narrow action when it comes to these types of issues. And the plaintiffs, they went on to say that when constitutional rights are at issue and criminal penalties apply, this makes it unique, especially with requiring the registering of parts, they said. They went on to argue that this is not an edge issue. It's not on the fringe. This is central to the overall law. The plaintiffs also talked about specific items like flash suppressors and muzzle brakes and how the definitions of those cause some confusion. Then the judge asks the defendants, the state, someone has an AR-15. The stock's adjustable. If they register but don't disclose the stock's adjustable, is that a violation? The state says that Illinois State Police guidance says if a stock is attached, that's sufficient. You don't have to register the stock if it's attached to the firearm. And they say that's part of the frequently asked questions on the website. Plaintiffs jump in and say the state's answer is another reason why this is all vague, because frequently asked questions, they said, are underground regulations and not force of law. If standard is arbitrary enforcement with police being confused, how is the public going to comply with this? Plaintiffs argued. They said that should be grounds to hold the state to a higher standard. They say that nothing further for their vagueness arguments. So the judge then gets the defendants to jump in and have their arguments for why the state wants the motion to enjoin the January 1st deadline to be dismissed. So the state argues that various due process points. They say plaintiffs are not people, being that, it's Federal Firearms Licensees of Illinois. I believe Guns Save Life there as well, and several other plaintiffs groups. It says that they're not people and they lack standing. The state says the rules have been filed properly and that they counter claims of insufficient notice. Also, they say it's wrong to have lower courts do something contrary to what appeals courts have done. Because remember, this case, at least the Second Amendment arguments, were in the Southern District Court. A Judge Stephen McGlynn issued an injunction prohibiting the state from enforcing the law. That only lasted 6 days while you had the state go to the appeals court to appeal. And they immediately essentially put a hold on McGlynn's blocking of the state law being enforced. That's the trajectory, at least for that Second Amendment case. That's now, possibly heading to the U.S. Supreme Court. But you've got the case on trying to block the January 1st deadline. That's what was heard yesterday in the Southern District. So the state says the plaintiffs have not shown injury and offer speculation on hypothetical injuries. The judge asks, why not send an email to all the FOID card holders? And the state talks about the process, and this is kind of interesting. The state attorney there said, well, when you log into the system, and the judge says, you've been checking in on me, Chris? That was a little bit of levity in the courtroom. But the state went on to talk about how they've followed the constitutional threshold of notification by posting the administrative rules. And they argue that what's being challenged here is facially. They're challenging the face of the law. They're not challenging the law as it's been applied. So the judge says standing issues are a concern, and the plaintiffs, they gave a response saying that if the standard would be to make any, the standing, the question of standing is, are they truly being injured by the law? Are they in the right jurisdiction? Are they the right person to bring this lawsuit? That's essentially what standing means. So you have the question of standing that the plaintiffs say, if they followed the state's standard, it would make any challenge impossible. They compare it to voting rights challenges, saying a lack of standing would make providing a negative impossible. It's reasonable for plaintiffs to surmise what members that the members are unaware of the rules. So yeah, a little bit chunked words here, but again, I'm live tweeting from inside the courtroom. The plaintiffs also talked about how you can't undo criminal consequences on the back end, right? So this is the difference between challenging the face of a law versus challenging how the law has been applied. So plaintiffs argue that you can't undo criminal consequences on the back end and have to pay lawyers tens of thousands of dollars after an injury. So the state responds that those arguments weren't briefed and says this case is not analogous to voting rights cases. They say that the plaintiffs have no response to the state's complaints against a temporary injunction, and they argue proper notice has been given through administrative rule and individual notice is not required. We talked about the JCAR process, and you can go and review that segment as well. But they went on to talk about the criminal statutes. They say case law is clear, and that's why they motion to dismiss Federal Firearms Licensees of Illinois' complaint. They say that the plaintiffs know the rules regulating highly dangerous items, and they talk about also various other case law. The state goes on to say that others not registering may be transferring them out of state, maybe selling them, or possibly destroying those. As to the registration numbers being low, they say complete speculation on why the numbers are low. Plaintiffs say they did argue their arguments in the briefs, and they say that because of egregious possible penalties, then they should be able to bring that challenge. The judge then went on to talk about the term assault weapon and said that that's used by some but not by others. We can't drag this out on appeal on drive-by filings. I think that was somewhat of a direct quote, but essentially he's talking about how the definition of assault weapon is a loaded term. Some people use it, others don't, and he also talked about how possibly enjoining this, you've got a lot of questions that are raised as to how long this is going to take. So he urges for swift resolution on the constitutional questions, as to what's happening here, what is and what is not protected. And he says that the Seventh Circuit mentioned only one firearm, the AR-15, comparing it to an M16, and talking about dangerous and unusual and so on. Now, it's a military-grade firearm. Other terms we've heard, weapons of war. But he says, Judge McGlynn said the Seventh Circuit's mentioned only one firearm, but 150 plus are banned, and says citizens deserve answers, as do law enforcement. The state talks about the vagueness argument some more, argues that plaintiffs claim a lack of notice. They address that separately. They argue vagueness claim won't succeed. They talked about a high bar that the arguments require. They say that courts are not super legislators and can't block laws that are taking effect. The state argues that case law shows that we're talking about issues on the margins. Continues on, but then the judge asks the state to argue the motion to dismiss. And this was a little bit of back and forth. Plaintiffs weren't aware that was going to be brought up. So the judge confirms that the hearing was indeed not on both the motion to enjoin the state's January 1st deadline and a motion to dismiss. It was only on the motion to enjoin. So interesting. Here's where it gets close to the end of the hearing, where the judge says that there's a mess. He says he hasn't made up his mind, but an injunction could make things messier, he said. He's inclined to deny the motion without prejudice to allow for another motion after January 1st. So when you say something, you're denying something without prejudice, that means, well, we can revisit this. If you say something, you order something with prejudice, that means we're done talking about this. So he's inclined to deny the motion without prejudice to allow for another hearing. He says from perspective of judicial restraint, that's likely how he will go. He goes on to say, until we start getting to making merit judgments on the case, it's going to be uncomfortable and an awkward period. People want answers now, but judge's job is to get complete record as the case moves up. You'll get my word on these one of these days on the final merits. The judge went on to say that we need the people of Illinois to get answers, what's protected. Until then, we're going to have a difficult time slogging through. The judge says there are going to be a number of applied challenges and continued confusion about registration, and the Supreme Court of the United States has indicated that prosecutors should not enforce unclear laws and rules. Again, I think that's important. He said that the Supreme Court of the United States has indicated prosecutors should not enforce unclear laws and rules. He says that they're going to be exploring this further on the merits of all of this in January and February. Plaintiffs argued guns are one issue, but it's the parts as well. Then they talk more about plaintiffs asking for clarification on possible relief from the Supreme Court of the United States because there are pending challenges there as well. So after the hearing wrapped up, the judge did say to expect a ruling promptly, but he reiterated that he has not made up his mind, despite clearly in some of those tweets saying that indeed they are going to likely not block the state's January 1st deadline, saying that could make things messier. And while all that's playing out, you've got the U.S. Supreme Court getting another filing, this time from State Representative Dan Calkins, who already had a different filing. And those filings were, ultimately about the Illinois Supreme Court's ruling on this and the lack of these individual justices that received campaign donations from recusing themselves. Well, now Dan Calkins has a motion for writ for an injunction. And you can go through and see this on this U.S. Supreme Court's website, talking about why they're looking to have this emergency action from Justice Amy Coney Barrett. And I'll let you read all of it yourself, but just looking at some of the highlights in the table of contents, they go on to talk about the facts of the case and the grounds presented in the docket in support of a likelihood of success on each. They talk about 14th Amendment due process grounds to vacate the Supreme Court's ruling on this, the Illinois Supreme Court's ruling, the opinion reversing the Circuit Court's final judgments, which invalidated the ban on Second Amendment grounds and equal protection grounds. They go on to say that the Illinois Supreme Court swept away federally protected Second Amendment rights affecting all Illinois citizens, and the guarantees clause in the U.S. Constitution in the harm to law-abiding citizens from enforcement during pendency of review. So they say that a stay is proper in this application. And if you missed the conversation I had with Jerry Stocks, who is State Representative Dan Calkins' attorney in this particular case, it's a lengthy interview, but I'd encourage you to check it out because he talks in detail about the conflict of interest concerns that there are, and how this all came about, and really talking about a true Illinois story, which is something that he also lays out in this document. He says, in sum, the Illinois story here is a legislature of two and a judiciary abdicating its duty of judicial review to allow well-funded, co-committed political factions to infringe federally protected fundamental rights, if there's any role for federal courts under the Guarantees Clause to assure that a state's allocation of powers between the branches of government is a Republican form, then the role is restricted to real or existential threats. Democratic Party of Wisconsin, quotes the case, the totality of circumstances here animates the existential threat, perhaps a different form of violence to the Illinois Republican form of government, a form of violence from inside the government itself, but violence nonetheless sufficient to invoke justiciability of the Guarantees Clause for the protection of all Illinois citizens from a lawless state government. So he talked about the Illinois story, a unique story, and something I think that U.S. Supreme Court Justice Amy Coney Barrett is being asked to act upon to put a stay on the law. So still some things in the air when it comes to whether or not in the courts they're going to act to block the January 1st deadline for registration, or if we're just going to see this play out into early next year and maybe even longer. So those are some of the latest updates here. Long update again. I know that there's a lot going on, and I think people are definitely interested in learning even more about where we go from here. It is Bishop on Air. Thanks for hanging out. Like, subscribe, follow along, and we'll be back at it, all right? So be sure that you connect with us on X, on Facebook, on YouTube, and also if you want to support the show, check out some merchandise below. All right, we'll see you soon.